Good afternoon. I'd like to thank everybody for joining us for today's webinar on the Davis-Bacon Act. We have a lot of people on the webinar today, so I want to be respectful of everyone's time. But at the same time, I want to go through some logistics issues first, and then we'll get right into the content. First thing is you should see a Q&A panel underneath the training slides. I would encourage you to submit your questions there throughout the training, and we will answer those towards the end of the training if we haven't picked them up along the way. I would also ask that, given the nature of our sign-in feature, that you also just submit a question with your name and email if you would like the slides from this presentation. Because we don't have a formal registration, and that'll be the easiest way for me to track who's on the call and to get that information to you. In addition, if everything goes right, we will have a recording of this training that will be available via a web link starting tomorrow, so that you can refer back to it in the future as needed, and or share it with other people within your organization who may benefit from it. When you do submit questions, again, please do include your name and email. As I answer them, I certainly will not identify anyone or call anybody out as the person who asked the question. But again, it helps me to follow up with you if your question, particularly if your question is a little bit tricky. And as we go through the material, you'll find that there are a lot of questions that could certainly fall into that category. So I think that's it for the logistics. Again, submit your name and email and look for the URL and the slides tomorrow. Okay, so what we are going to accomplish over the course of this webinar is to basically ensure that everyone understands, whether you're brand new to government contracting or whether you've done it in the past, or maybe you've done it in the distant past and not recently. We want to talk about what the law is, what it requires, what the compliance requirements are, both from the Department of Labor's perspective, but also what our company requires. And there's kind of two different things, and they're obviously heavily overlapping in parallel, but they're not exactly the same. So it's important that all of the subcontractors, and particularly lower tier subcontractors, which we'll talk about a good bit, it's important that all of this information flows all the way down to the lowest level of tiered subcontractor that may be performing work on these projects. Okay, so we'll also learn who, what, where, when, and how the law applies. We'll talk about kind of some of the common things that people have done wrong, some of the obvious pitfalls that we want to avoid, and we'll talk about where you can go for future information. So first things first, what is it? The Davis-Bacon Act is a really old law. It's really probably one of the oldest ones outside of the False Claims Act that we deal with on a regular day-to-day basis in government contracting. It's a 1931 law that stems from the Great Depression that was intended to equalize wages on government projects. So if you think back to 1931, this is before the Fair Labor Standards Act was passed. It's before we had a nationwide minimum wage. And you had people going from town to town who were kind of disrupting the wage economy, because they would go from, maybe a poor neighborhood to a richer town, and they would be willing to work for less. And since there was no minimum wage, that would disrupt the local labor market. So this law was intended to eliminate that practice by establishing a floor, which is a minimum wage. It's certainly not a ceiling, and it's not a mandatory wage, but it's just a floor, a minimum wage for laborers and mechanics, and we'll define those, who are working on federal public jobs. The important thing in the second bullet point here is that kind of the buck stops with the prime contractor. So if you, a subcontractor or a lower tier subcontractor or a lower tier subcontractor, have any sort of non-compliance problems, the Department of Labor will certainly address those with you, but they won't waste a lot of time trying their enforcement hand with you. They will immediately go to the prime contractor, and they will withhold money directly from the government. And so as a result, you'll find that we will often act very much the same way. If you have a subcontractor and they turn around and hire another subcontractor, and that subcontractor has a problem, we're not going all the way to the bottom to figure out what the source of the problem is. The buck will always stop with the highest level of contractor available, and that will generally involve payment withholding, and other types of action until we can get the problem quickly and appropriately rectified. We'll talk about those as we go through. So a little bit more history on the Act. Again, I mentioned it's a 1931 Act. It's really been unchanged in the language since 1931, and for that reason, it's got a very low dollar threshold. It's only $2,000, which might have been meaningful in 1931, but it's obviously not very meaningful today. What it means to us is it applies to all construction jobs that the government issues, period, regardless of size. If you've got jobs that have some service elements and some construction, it really kind of depends on the contracting officer, but that job might be covered by the Davis-Bacon Act. It might be covered by something else called the Service Contract Act, which we're not going to talk about today, or it might actually be covered by both. And so really this is just a note that it kind of depends on what the contracting officer sees as the main predominance of the project. What is the primary purpose of the project? Is it construction or is it services? And they will then apply, with Department of Labor's input, the law that they feel is the most appropriate. For the work that we've got going on in North Carolina currently, it's primarily going to be all construction. We don't have Service Contract Act covered task orders at present, so that kind of keeps this very simple for us. Moving on, as I mentioned, what does the DBA do? It supersedes the Fair Labor Standards Act, and it provides a minimum wage, not for all of your employees, but for those who are engaged in laborer or mechanic type of work classifications, and we'll talk about what that means, on these government projects. So what that means is a minimum wage is just what it sounds like, right? It's a floor. It's not the specified wage. It's certainly not the maximum wage. It is the floor. And our experience thus far has been that the wage determinations, which is the paperwork that specifies what that wage is relatively modest within the South. That's not true in all parts of the country. So, but in the South, what we're kind of finding is that the market wages really are probably, in almost all cases, significantly higher than what's on the wage determination. This is good in this area because this really cuts down on the possibility of having financial noncompliance. There's still a lot of administrative noncompliance that we'll talk about, but it basically means that, for example, if the wage determination requires a $13 an hour payment to a given classification of laborer, but the market demands that you kind of pay somebody $20, otherwise people just won't work, then it's very unlikely you're going to have a non-compliance simply because the market is not allowing you to. Now that said, there's still a lot of paperwork that you could mess up, and you could have administrative non-compliances, but we'll talk about what the differences are there. In addition to the wages, some, but not all, of the labor categories will also have a fringe benefit pool. So that'll be a cash fringe. Generally with Davis-Bacon Act, you don't see holidays, vacation, or any type of insurance. I mention that because you do see those things with the Service Contract Act, so if you're used to that, you do want to understand that there's a difference. And then, as with any wage determination, you definitely don't want to assume anything. You're going to read it cover to cover and make sure that you understand any little nuances that are there. So again, for those people who are kind of focused on North Carolina right now, that one is pretty straightforward. But to the extent, if you're listening to this webinar in the future and you're concerned about a different geographic area, make sure that you read your wage determination page by page, because some of them are very, very complicated. The ones in the South tend to be a little bit more simpler and straightforward. So where does the Davis-Bacon Act apply? For us, it's going to be in all 50 United States. In addition, some states have their own little mini DBA laws if you're doing state work or muni work. We're not really focused on that right now. We are a federal government contractor, and that's kind of the purpose of this particular webinar. So it applies within the 50 United States, but then within the 50 United States, it doesn't necessarily apply to every single person doing every single thing. So for Davis-Bacon Act, it applies just to the direct physical side of work, okay? So even, and it's kind of hard to figure out how this would happen, but if you had laborers or mechanics who were working somewhere else, let's say they were working in a fabrication center, making something that was going to be brought to the site, they would not be covered because that is not the direct physical side of work, okay? So same thing for borrow pits or quarries or delivery drivers who are far away from the site who may come to the site. The work that they're doing that's not on site is not going to be covered. Courts have looked at this. A number of times. The regs don't spell it out quite this way, but the case law says that to be covered by the Davis-Bacon Act, the employee needs to be at the project site or immediately adjacent to it. So for example, if you started up a borrow pit right next to your project site, that would probably be covered. But if you're going to a quarry 2, 3, 5 miles away, that would not be covered. Okay, so if you had a brick yard or some other supply yard that was miles away, that would also not be covered. So the types of employees that are covered are going to be your laborers and mechanics only. So just think of this as your traditional craft and trade. It's going to include your truck drivers, pipe fitters, carpenters, glaziers, painters, millwrights, mechanics, that sort of thing. It will not include your administrative personnel, your white collar types of workers, or anybody like that. Just laborers and mechanics as defined by the law. And if you have a question, although these are usually pretty black and white who's who, but if you have a question, certainly ask your ECC contract administrator and we'll get you a ruling ahead of time. The important point here on the last bullet is this applies at all tiers of subcontracting. So the law covers the employee. It doesn't matter who they work for. If you have a second tier sub and then they turn around and get a second tier sub, which we strongly advise against for a lot of reasons that we'll talk about. But if you've got multiple levels of subcontracting, the employees are covered all the way down to, if the last level of subcontracting hires them from a temp agency, they're still going to be covered. So the law covers the employees regardless of their employment situation or regardless of their distance away from the prime contractor. There are a few exemptions. I'm going to go through these very quickly because they're largely not applicable to Davis-Bacon Act. The first one is just the executive exemption. That would basically take your managers out of Davis-Bacon Act coverage. So the requirements there would be that you've got somebody who's managing, quote unquote, the enterprise, directing the work of 2 or more employees, and has the authority or the great weight to recommend such things as hiring, firing, giving raises, things of that nature. So if you have somebody who was a roofer and then they were a working foreman and worked themselves up to project manager, he or she would probably fall under the executive exemption. And even though they may have a history as a laborer or mechanic, they would be exempt and they would not show up on your certified payrolls, which we'll talk about in a bit. The second exemption is administrative, but since Davis-Bacon Act only covers your laborers and mechanics anyway, and not your white collar workers, this exemption is kind of superfluous. It doesn't really work to exclude any additional people. And then the third exemption for Davis-Bacon and for Service Contract Act is those that are doing specialized intellectual or artistic, including computer-related occupations, which again, it's very rare that we have any overlap between laborers and mechanics and somebody who would fit into this particular exemption. So chances are you'll know who your laborers and mechanics are pretty clearly, and you won't have a lot of confusion about exemptions. But if you do, as with anything, we encourage you to ask and get a ruling ahead of time rather than wait for there to be some finding by Department of Labor after the fact. So the next topic we're going to talk about here is the conformance process. This is a little bit non-chronological, and I apologize for that because we haven't really talked about wage terminations, but we're going to look at those in a moment. On the wage termination, you'll have different labor categories, and they can be quite complex. So, for example, rather than saying laborer, there might be 3 or 4 or 5 types of laborers, and instead of saying equipment operator, there could be 10 or 15 different types of equipment operator. And again, depending on the geography and where you are in the country, some of these wage terminations can be incredibly complicated in terms of mapping out the labor category. However, that said, it is entirely possible that you may have a labor category that you think is not on the wage termination or doesn't fit cleanly. And so what we would ask you to do is look for something that's kind of similar enough to your labor category, both in the skills and the experience that would be required, and would it be an equivalent rate of pay and those sorts of things, and see if there's a fit. Even if the Department of Labor calls somebody by one name and your company calls them by a different job name, is it really the same thing? And if it is, then we just harmonize those names when we fill out the certified payrolls. If there's not a match, then you go through something called the conformance process. And I mention it here simply because I mention it kind of as a yellow flag. It's not something that you want to enter into on your own without talking to us, because it's easy to mess up and it can have ramifications for both your company as well as all the other subcontractors and the prime contractor on the site. So do not fill out the conformance process in the field. I just want everyone to be aware of it. And if you hear somebody talking about conformances, we should all be having a conversation to make sure that it's appropriate, because they are appropriate in some circumstances, but they are not appropriate in a wide variety of other circumstances. Okay, once the work has started, I just kind of mentioned I do not want anyone to fill out conformances. Conversely, everybody has to fill out a different form, and that's called the WH-347, what we will just refer to as certified payroll from here on out. So the certified payroll form is a form that you can pull off the internet. You can get that from the Department of Labor website. And we have a smaller picture of it here. We'll look at some bigger pictures in the subsequent slides. But basically what this form does is it's a form that gets turned in weekly that will list all of your Davis-Bacon Act covered employees who will be on the job, the cash that they are receiving, the wages they're receiving, the benefits that they are receiving, if you've got fringe benefits with their job classification, the deductions that you've taken out of their payroll, the taxes and any other authorized appropriate deductions. And then there's a second page to it, which will be a statement of compliance, which an authorized person at your company will fill out and sign under penalty of perjury, saying, these are the wages my people have been paid, and I certify that this is true and correct. Okay, so on certified payroll, those have got to be turned in to ECC, and then we turn them into the government. That starts immediately. Okay, so the very first week that you work, certified payrolls will be due, and the timeline kind of works like this. Let's say they work from August 1st to August 7th. That's the week. And by the way, for Davis-Bacon Act, payroll is weekly. So if you have other employees and you have biweekly or semi-monthly payroll, for Davis-Bacon Act, it's going to be weekly payroll. And so after that first week of August 1st to August 7th, let's say you close the payroll period on the 7th, and those individuals get paid the following Friday on the 14th, okay? And then your certified payroll will be due 1 week after the pay date, okay? So the certified payroll then technically becomes due on the 21st. It is critically important that certified payrolls be kept up to date and be turned in every single week. I cannot overemphasize how easy it is to get behind and how near impossible it is to get caught up once you get behind. If you get 3 or 4 weeks behind and then turn around and realize that some subcontractors are not on the job anymore or didn't keep the right records 4 weeks ago, and you're going to be asking them to recreate the records, it gets to be a big mess very quick. So 100% critical that those certified payrolls be turned in on time. Like I said, they are condition precedent to getting paid your invoices. So, you know, we will certainly have everyone's attention on how important they are. I see one question here, and the question I think is covered in this slide. Can you use your own form of the WH-347? And you can. Somebody said, you know, can I use the QuickBooks version? And the answer is yes. Can you make your own Excel version? And the answer would be yes. And so you can do that as long as it has all of the same information that's on the WH-347. Don't get too cute or creative by trying to, you know, leave something out that should be there, because we'll catch it, DOL will catch it. But in terms of just ease of filling out the payroll, if you want to do it in Excel or QuickBooks or elsewhere, you can certainly do that. I also don't know the form that you pull down off the website. It's a fillable PDF. I don't know how easy it is to manipulate in terms of importing data. But again, as long as you've got all the data that the form requires, you can use your own form. When that form gets turned in the very first time, you're going to have your employee's name, address, and social, or a kind of an employee-specific ID number. In subsequent weeks, you don't have to include that ID number unless there's been some sort of a change to it. The next thing is very important. You should number all of your payrolls sequentially. So the very first week that you turn one in, it's got to be labeled number 1. And on and on and on until your job is over. and the last payroll that you submit should say final. If you have a period where you don't work, let's say July 4th was on a Wednesday, and you just decide it's so disruptive, you're going to just take that week off and give everybody some time off, and you do no work, you still need to submit a certified payroll that has no names on it, no hours, no wages, and it says no work. And the reason for this is because if you don't submit it to us, we're going to assume you forgot. And that's going to hold up invoicing. That's going to cause people to call you and say, where's your certified payroll? And with 50 subcontractors, we don't need to be tracking everybody down saying, hey, did you work this week? Okay, you didn't. That's why I don't have one. It's much easier for us just to get a no work certified payroll. And also that way, when we are doing audits and the Department of Labor is doing audits, which they've already done extensively on this site and will continue to do, they can get a stack of certified payrolls and just go through them and see 1, 2, 3, 4, 5, and the weeks will also be sequential rather than 1, 2, 3, skip a week, 4 different dates, and them having to come back and asking us all the same questions. You know, why is there no certified payroll for the week of July 4th? Oh, you know, I'm not sure. I have to call them and find out. I don't think they were here. So please give us the no work payrolls if there's no work. If you're going to be off work for an extended period of time, let's say you're taking the entire winter off, you know, because your work is not conducive to winter work. If you're going to be taking 2 or 3 months off, then you don't have to do it for 2 or 3 months, but just let us know with a piece of paper, a formal letter, and we'll figure out when you restart how we handle the sequencing and the serialization of the payrolls. What's on the payroll? Pretty straightforward, but we'll look at ways that are the right way to do it and the wrong way to do it. Your project name will be there, the subcontractor's name and address, and again, if you've got second tier or lower, their name and address. If you are a subcontractor and you've subcontracted to other, you do not report their payroll. That needs to come from them. And it's very important for us to know who's working for whom all the way down the chain for exactly this reason. So if I get a payroll, an email from LMNOP contractors, but I don't have a subcontract with LMNOP, that means they've subcontracted to somebody else. And if I don't know who that is, I don't know who, kind of which pile that goes with, or who gets credit for turning that in, and who's in the chain. So we'll look at a form called the SF1413 in a bit, but again, this is another reason why we discourage overuse of lower tier subcontractors. Try and keep it as flat as you can, but to the extent that we're doing it, they've got to be reported who's working for whom, and then if those subcontracts to others, that's when we really want to talk long and hard about trying to keep that to a minimum, because every additional tier kind of really makes it exponentially greater chance that we're going to have non-compliances. In addition to the contractor's name and address, you'll have the ending week date of the pay period, and then the work classification. So for work classification, the pitfall here, and the number one thing that's critically important, is your job title must match some job title from the wage determination. Okay, so we'll look at some of these wage determinations, particularly even for the North Carolina area. If there are 3 categories of laborers, you cannot write laborer on the certified payroll because that's not specific enough. You've got to have exactly the right type. If you've got an equipment operator, it needs to specify exactly the right type. If you've got a guy that you call glazier, but that job title doesn't appear on the wage determination, you can't write that down. You need to figure out what that person's actually doing that's appropriately classified to a job title that is there, whether it's a painter or something else, and make sure that you've got a labor classification that is both appropriate for what the work the employee is doing, but also that matches a wage that's on the wage determination. If there is no match, then we go back a few slides to that conformance discussion again. If you just put laborer, and there's 3 categories of laborers, and you don't specify, the Department of Labor by default will assume that he is the highest classification of laborer and that you must pay them the highest wage rate of all the classifications. So you can have an accidental back pay problem if you are not specific with the job categories. Payrolls must also include whether the person is an apprentice or journeyman. I haven't seen this distinction on any of these jobs yet. The only way you would do that, we have some union subcontractors, is if they have an appropriate apprentice program, and then they would have the appropriate certification papers from the Department of Labor showing that people are in fact in an approved apprentice or journeyman program. If none of this sounds familiar to you, then it clearly doesn't apply, and you shouldn't be checking those boxes or making those notations. The next sequence of data will be the hours worked, and that'll be per day. And then you'll also have the rate of pay, and that'll be broken down on two lines, both by regular time and overtime. So overtime is pretty straightforward. Any time that is spent over 40 hours a week will be overtime, and that has to be paid at time and a half. And that's both Davis-Bacon, but it really is Fair Labor Standards Act. And then there's even some other acts like Contract Work Hours and Safety Standards Act, which all deal with the 40-hour per week issue and gives the Department of Labor several tools at their disposal to make sure that employees are paid appropriately time and a half for any time that they spend over the 40 hours. If there are any cash fringe benefits, they don't have to pay the fringe benefits part at time and a half, but they do have to carry that at straight time for the hours that are over 40. And then finally, the last thing from this slide that'll be on your certified payroll is just a gross up of all those numbers. It's just straight math. After that, you'll have deductions, and that'll be your taxes. If you've got health insurance or any sort of other deduction, if they've got child support or court-ordered garnishment, that will show up on this form. And any other sort of deduction will appear on this form. And then the last column will be net pay. So gross less deductions equals net, not terribly complicated. The second page of the form is the statement of compliance. Again, this will be where an authorized and responsible member of your organization fills out that the wages and the data contained on page 1 and or page 2 and 3, however many employees you have, is all correct and accurate. And that you will check box 4A or 4B, and we'll look at the form in a minute so that you know what we're talking about. And that will discuss whether employees are receiving a cash fringe or a fringe that's being paid into some sort of an approved plan. So in other words, you might not be giving them 38 cents an hour for vacation, but there might be something going into some sort of vacation fund or pension fund that is specifically designated to them and is approved. The last thing there will be the signature, and again, that goes with an officer of the company, treasurer, or payroll administrator. It can't be the signature of, the temp that you hired last week. The issue here, obviously, is that this is a certified payroll. That means whoever signed this is going to be subject to the False Claims Act. It is a very serious document, and so it needs to be signed by somebody with the appropriate authority and understanding of what it is that they're signing up to. People can get sued, indicted, and in a lot of trouble for submitting false certified payrolls. And in other companies, that's exactly what's happened. So you don't want to just give it to somebody and not let them know what they're getting into and saying, hey, you got to sign this person who started here last week, and think that you're going to avoid trouble by having somebody sign it who lacks the authority to do so. The last thing there will be a definition of fringe benefits, and we'll look at that when we get to the form here in just a moment. Okay, a handful of things about the form. I already talked about the site of work, and that's going to be, who goes on the form. It's your laborers and mechanics who are on the job site. For us, that's going to be largely means they're on the building or in the building. If they are, doing some sort of fabrication somewhere else, and everybody's got different scopes of work, so I'll try not to be too specific, whether it's HVAC or interior rebuild or roofing or what have you. But if they're working several miles off the job site, those hours don't go onto the form. It's just going to be the hours that are covered. So non-construction site like a manufacturing or anything like that is not covered. And then if you've got any sort of employees or subcontractors that are doing incidental installation, in other words, if they deliver a washing machine and they kind of set it up and level it and plug it in, that's not going to be covered by Davis-Bacon Act. Okay, so they wouldn't be on the payroll. Delivery people who, start off in Raleigh and make their way down to the site and then, stand by their truck while or even help unload it, Again, generally not covered, and certainly not covered when they're driving away from the site and are far away. Field interviews will be conducted both internally by ECC as well as by Department of Labor. They've already been out on these jobs a number of times. We're working very closely with them, and they will continue to do that, I think, through the life of these projects to interview employees. And they'll ask them, a variety of questions. We'll actually look at the form that they go by for their interviews, but they'll ask the employees, what are they doing? What are they making? Are they working over 40 hours? Have they received overtime? Have they had unauthorized deductions, et cetera, et cetera? So there are certainly a lot of checks and balances and ways to find out and ensure that compliance is being done properly. Okay, certified payroll, as I kind of mentioned, the completion of the WH-347 is optional, but it's got to be the same type of information, whether you use a QuickBooks or a Excel or any other type of form. So hopefully everyone can see this one on the screen. It's still a bit small, but again, this is just everything we've talked about. So in our first column there, we've got the name, and you'll have the identifier of the employee, whether it's their social, last four, or unique identifier. The labor classification there is the third column over. Then you see the multiple days for hours per day, and you see 2 rows there per employee. Again, you'll have regular time and you'll have overtime. And then as you move over towards the right of the form, you'll see our deductions, and then ultimately the net pay at the bottom. The certification page looks like this. You'll put your name, your title, the name of your company. If you've got any sort of deductions, this is where you would list and articulate what those were. I deducted $127 from John Doe because we've got some court-ordered child support that I have to send to the court. Or I deducted $38 because I have a garnishment order from the IRS. And so those deductions all went to those government agencies. Or he's enrolled in a company-sponsored healthcare, and we've deducted $48 for his, share of that cost, whatever the case may be. You also see 2 boxes there. You should have one of those checked, if not both. And it really just depends on your employees. Like I mentioned, some employees have fringes, some don't. It depends on the labor classification. So you could have employees that are, receiving things in cash, fringe, employees that are not due any cash fringe at all, and you could have employees that may be receiving fringe in bona fide benefits. They're not actually receiving the cash. And you just need to check whichever box is accurate. So highlighting some of the correct things to do with the form. Just kind of, when you get the slides, take a look at this and use it as your go-by. You've got to have your company name. You're going to be checking the box that you are a subcontractor, you're not the prime. You'll have your company address. You see the last 4 there of the social of your employees. You've got your hours totaled. You've got your fringe benefits listed out. Basically all the things that I've been talking about. You just need to make sure that it's accurate, complete. And we do look at every single one of these that comes in, and we look at them week by week, and we will look at them from your lower tier subcontractors, and if they exist, they're lower tier subcontractors. So there's no file and smile. These things get reviewed, and if there's a box that's missing, it's going to get turned around to you. It's going to get rejected, and you're going to be asked to refill it. The certification form, pretty straightforward. Just make sure you've got all the data filled out and that it's properly signed. This one is a little bit hard to see on the slides, but I'll just kind of walk through some of the problems that would exist with it, and we'll look at them when they're highlighted. And then same thing for this form. So an incorrect form would be lacking, as you see on the right side there, lacking social for one classification, for one employee, I should say. For a job classification, an incorrect way to fill it out would be to have a too generic or an incorrect labor classification. I'm gonna call Bob a laborer when there's really more than one type, and I should have been specific. If I have more than 40 hours in my regular time row, something's wrong. That should always be maximum of 40, and everything after that is going to be in the second row, which is your overtime. You see in this form they filled out all the hours in the overtime row, and that would certainly get attention. You see for the third employee here, there are no deductions. That certainly is a yellow flag. One of the things we haven't talked about is the concept of independent contractors, and I will talk about them. By and large, the concept does not exist under the Davis-Bacon Act paradigm, and the Department of Labor will consider that to be a huge red flag. If you look at what an independent contractor is under the IRS tests, really there should not be any laborers or mechanics that would be subject to Davis-Bacon that would also qualify under any of the tests for independent contractors. It's an area that contractors frequently try to use for a variety of reasons. Might make it administratively more simple for them. Maybe the employees just don't want taxes taken out. Whatever the reason, those reasons are not valid. And if we see independent contractor, or if we see somebody with no deductions, there's going to be questions, because chances are that probably means we have a non-compliance brewing. On the statement of compliance forms, it's kind of hard to not fill this one out correctly, but again, failure to check the right box or both boxes, failure to sign it, failure to have your name in there would be ways to have this done incorrectly. So again, when you look at the slides and when you receive them, you'll be able to see kind of some of the specific do's and don'ts on the payroll. My experience is that once you've been through the first couple of weeks and you receive feedback on any issues, that after that it should be pretty straightforward, and you should you really won't have any problems on a go-forward basis. I mean, once you have it down the first couple of weeks, after that it's really very routine. The only pitfalls at that point become, again, if you take a break from work and you start up again, or if you change personnel internally, right? If you have it being done by one payroll clerk or administrative person for a couple months, and then if you have turnover, that is again where we see non-compliance, simply because you get new people who haven't been through the training and don't know all the little tricks and the ins and outs of filling out the form. Okay, so here's a good example of kind of the example that I've been talking about, making sure that you have the right kind of classification. As you see here, this wage termination has 4 different types of laborer at least. It could be a common laborer, a landscape and irrigation laborer, a pipe layer, or a mason. And so there are 4 different rates for those types of laborers. So again, if you don't fill out what type of laborer that is, the Department of Labor will probably take a look at this and say, well, they didn't specify who it was, so we just have to assume that these were all pipe layers, because that's the highest rate. And if you had somebody who was legitimately a common laborer and you paid them $12 an hour, which would be over the mandatory minimum, and you would be in compliance, but if DOL just assumes that everybody's a pipe layer, then suddenly you're $1.35 out of compliance, and you would end up owing employees a lot of back pay. This is something that we obviously want to avoid. Okay, one of the things that we'll provide for you is a checklist. We'll get that out to you with this. If you haven't received it already, you'll receive it with these slides. Let's talk about a few other pitfalls. Some of these may seem really obvious, but do not, under any circumstances, pay people in cash, okay? Because the way that this gets audited is through payroll records. And if you pay somebody in cash, or they pay subs in cash, or your lower tier subs pay people in cash, it really is impossible to document appropriate deductions and how much money they actually made. And so I've heard all sorts of stuff here. Somebody says, "Oh, well, we had them sign a thing saying how much cash they got." Okay, I hear that, but I'm telling you, from the Department of Labor perspective, they're going to say, what type of legitimate company in 2019 doesn't have a payroll system that properly tracks payroll, records hours, makes payroll deductions, sends that money to the IRS and wherever it's supposed to go, and is out on a federal government project handing people dollar bills? That just doesn't really pass muster. So please, if you hear of it, if you see it, if you have any inkling that it's happening, please talk to us, because it is a huge red flag. The case in point here that we have on the slides kind of just demonstrates what the downfall can be. There was an employee on a lower tier sub on an old project that we did in New Orleans, and after 5 months, the employee went and said, I don't think I've been paid what I'm supposed to be paid, under the Wage Act. And Department of Labor said, you know, where are the records? And the lower tier subs had no record because they've been doing exactly what I've been talking about. They've been paying these employees in cash. Now that brings up a wide variety of other issues. That means they probably also have IRS payroll problems. They probably got workers' comp problems. They probably got a whole host of problems that are beyond the purview of this training. But just in terms of Davis-Bacon, what it did is it caused the DOL to say no records means you haven't paid them anything. And so they ordered the subcontractor to pay back pay for a period of 5 months. And so I would look at this kind of organically and say, is that reasonable? I mean, did somebody really work for 5 whole months without receiving any pay? Certainly they must have received something, but the answer is it doesn't matter, because if there are no records, this is kind of how strict and formulaic the Department of Labor will approach their back pay calculations. Other pitfalls, don't forget the FLSA rules regarding overtime. These projects and many Davis-Bacon Act covered projects frequently work non-traditional more than 40-hour schedules, okay? So if you've got people working over 40 hours in a week, make sure they've got time and a half, okay? The next box there, DOL, as I've already mentioned, will look very strictly at any claims that your individuals are independent contractors. That's just really not a thing on a Davis-Bacon Act project. And the Department of Labor, I find them to be very professional, nice, friendly to work with, but they don't have a lot of flexibility or need to be, right, in terms of how they enforce the law. So they will give back pay orders pretty quickly. And there's not a lot of negotiation or compromise or bargaining with the Department of Labor, right? They are an enforcement agency, and generally when they calculate your back pay, you're going to end up paying back pay. That's kind of the end of the story. This next document is one on misclassification for independent contractors. I'm not going to go through this one in great detail. This is available on the Department of Labor website, but again, it just shows you the myriad of rationalizations that people have used in the past to say, hey, this person's an independent contractor. And then you also see, you know, for every story, the Department of Labor has an answer, which is, yeah, not really, right? So the fact that it's, quote, common industry practice, that's not going to make it so. The fact that an employee wants to be an independent contractor, they don't want to be an employee, makes absolutely no difference. The IRS test and the DOL test depend on what they're actually doing and who has control over them. And it's very rare that you're going to be able to say that some labor mechanic has complete control over their schedule, their means and methods. They work for any client they want to on any given day. They use all their own tools and equipment. They decide when, who, what, where, and how they're going to work. It's just not a thing within the construction industry. All right, in addition to DBA, we've also got DBRA, which are Davis-Bacon related acts. I think, again, the only one that I wanted to focus on was the Contract Work Hours and Safety Standards Act, because, again, that gives the Department of Labor both the power to enforce time and a half over 40, as well as to impose a liquidated damages penalty on employers that have not done that. So if you haven't paid your employees overtime and the Department of Labor finds that in addition to DBA problems, you've got a QASA problem, the QASA problem will cost you, I believe it's $10 per employee per day. So that doesn't sound like much, but it can add up, certainly if your crew is large and your problem has been going on for a while. Like I mentioned before, the Department of Labor will give back pay orders pretty freely. They will even order you to pay back pay to employees that they can't identify. So think about this example. If they talk to an employee and that employee says, I haven't been paid the right wages, they will also then say to that employee, who else was working on your crew? And that individual may say Bob and Terry and Jose and Jane. Those were the 4 people that I remember working with. And the Department of Labor will say, do you know any of their last names? And they'll say, nope, I never met them before. I don't know their last names. You will still get a back pay order for 4 unidentified individuals while the DOL continues to search for those persons' names and socials, okay? And if they are never found, that doesn't mean that you don't have to pay them. When they issue a back pay order like this one, you have to pay the employees, and if for some reason you cannot locate them, you have to send that money to the U.S. Treasury. So again, I want to really emphasize the, kind of draconian and finality, the final nature of a Department of Labor back pay order. Once they issue it, You're not going to negotiate your way out of it, and you're not going to get lucky by saying, oh, well, you know, we sent Jane a letter and she didn't respond, so I don't know where to send her a check, so I guess we'll just keep it. It doesn't work like that. Whatever number is on this form, that's the number you'll end up paying. And it's really just a matter of, you know, all the additional administrative costs that you're going to spend trying to track these people down. So audits and investigations, I talked about a little bit before. The Department of Labor, as well as internal at ECC, we will conduct compliance interviews with your employees. They'll be asked their payroll history. They'll be asked for the names of their coworkers. These, you know, generally happen with some level of coordination. They're generally not complete and utter surprises, but at the same time, you know, they're not going to give you 4 weeks to, you know, a heads up so that you can get your house in order and get all your payroll done correctly and, you know, tell all your problem employees to stay home that day. It doesn't work like that, right? So it is an open and transparent audit and investigation process. And the best way to get through it is just to kind of, from my experience, embrace it. Make sure that you are in compliance at all levels. Do training with your lower tier subs, and make sure that you know, are cooperative, and answer as many of the questions correctly and all of the questions truthfully as much as possible, so that they will move on and go focus on some other contractor. Last box here, in addition to the Department of Labor, the government contracting officer also has authority for enforcement. So, you know, even if it was not DOL, the Navy also has the ability to come in and do interviews. So you've got multiple levels of checks and balances and audits on these projects. The audits can happen in real time. Obviously, they like to get people when they're out in the field. We like that to happen too, because it happens pretty quickly. But also they could come back 2 years from now after the job is long over. And if they find problems, they have the ability to issue findings even years later. And those findings can be very difficult to fix because, you know, records might be, you know, not as available. Employees are gone, hard to track people down. And if records haven't been maintained, it's virtually impossible to recreate them. So again, they've got a long statute of limitations, long list of ways to really impose their enforcement. If you look at the records, they're pretty telling. Since 1985, the department has found well over 100,000 violations. They've awarded several $100 million worth of back pay. Last year was a relatively big year for them, 850 investigations. About 3/4 of those resulted in some type of violation. Some of those include back pay, some of them are just administrative. $45 million in back pay last year. And then this is the big one, because I haven't mentioned this yet. 19 companies were debarred, and that means you can no longer work as a prime contractor or subcontractor at any level, at any tier on a federal government contract. So you generally won't get debarred on your first violation or if you have a problem. But if the Department of Labor finds that your Davis-Bacon Act violations are willful, or if they are repeat, or if they are fraudulent, they will put you up for debarment. And, you know, similarly to, you know, their enforcement, I don't want to say that the debarment is automatic. You'll get an opportunity to state your case. But if the facts dictate that you did something wrong, or you did it intentionally, willfully, fraudulently, or over and over and over, there is as high likely as not chance that you are going to be suspended or debarred from government work. The construction industry is obviously the hardest hit, again, because Davis-Bacon covers laborers and mechanics. That's not terribly surprising. And the states where we see the biggest problems are Texas, New York, and Florida, which is a little bit surprising. New York, I'm not surprised by, because the rates are very high, so it's easy to have compliance violations there. Texas and Florida tend to have slightly lower rates, so it means that people have really probably gone out of their way to have violations, and or there are probably a lot of administrative violations there. This poster shows what should be posted at the contract site. I realize that most of your jobs, you may not have a situs necessarily of where a brake trailer or anything like that, but I would make sure that you have this form, and we'll send it to you, and it should be in your foreman's truck. It should be with whoever's doing tailgate safety meetings. It should be a form that is available to employees if they have any questions, so that they know who they can go talk to if there are any problems. This form is the labor standards interview paperwork. I talked about this earlier. It just goes through, again, what we will use, but it's also the DOL form. It's their interview checklist, right? So if you want to prepare for compliance, this is actually a pretty good place to start because it'll tell you everything that your employees might get asked, right? So if you look at this form and you know everything that they might get asked and you can envision the universe of what their answers may be, you can figure out what you need to do to make sure that you are in compliance above and beyond everything that I've already talked about. There is one exception to the cash fringe rule, and it probably doesn't apply to most, but it might apply to some subcontractors. If you have union subcontractors and you're not paying those fringes in cash, but they're going to a fund, it doesn't make the dollar amounts on the wage termination any higher or lower. They're still the same. But rather than those payments being made every week, you would probably make them to the union on a once-a-month basis. And you would, at the 4-week intervals, you would just need to submit proof of payment to the union fund, and that'll go along with your certified payroll. If anybody is unionized and they have this type of situation, please talk to us and we'll just work through it and make sure that, you know, the peculiarities of your situation that we've accounted for and that everybody's on board. Okay, so wage determinations is kind of one of our next to last topics, and so we'll move into actually looking at the ones for this job. We've already talked about what they are, and we'll talk about kind of some of the pitfalls with wage terminations. The main pitfall is to make sure that you're using the right one, because there are different wage terminations both for different counties, but also for different types of construction. So you need to make sure that you're using the right wage termination. And then once you've got the right wage termination, then you also need to make sure that you're using the right labor classification from that wage termination. Okay, so this slide covers everything I think I just said. But right WD, right labor classification from the WD, right county. And not every WD batches up all their counties the same, right? So some wage terminations, you know, will have 2 or 3 or 4 or 20 counties together that all have the same rates. And some will do it county by county, or maybe just 2. So don't assume that if you see your county on one wage termination that it's going to be the same way on the next one. And this slide gives us a good example of that. So the first thing is to look at where it says construction type. Okay, so you'll see one says building and the other one says highway, and that's obviously 2 different types of things. So if you're doing paving work, you're not going to be looking at the building wage termination. If you're doing roofing or HVAC, similarly, you're not going to want to look at the highway wage termination because that's going to mislead you. The second thing is, once you have picked out the right wage termination for the right type of work that you're doing, you want to make sure that you have the right county. Most of our work will be under building, but be aware there are highway determinations. There are also heavy construction type, heavy civil, so that would be your earthwork and things of that nature. And then even within certain wage terminations, there can be multiple different categories. So within in some states, say for example, the building classification, you could have 2 different sets of rates for residential versus commercial, or say for example, 3 stories and lower buildings versus 3 stories and higher buildings. So make sure you read that wage termination cover to cover and you understand exactly what type of work you're doing, exactly where you're doing it, and then as we move on to the next slide, exactly what type of work your person is doing. So this is a page from the North Carolina wage termination from January of this year for building construction. And as you see, one of the areas we already looked at, if you look about midway through that wage termination, you see laborer. There are 4 types. So again, you want to make sure that on your certified payroll, you're listing the proper classification for your type of laborer. But then look down at operator. For equipment operator, there are 6 or 7 different types. So again, you want to make sure that you've got the right type of classification for that operator. Now, one of the questions that people frequently have is, what do I do if I have people that are doing more than one thing? Let's say I've got a guy who works on a grader, and he grades out an area for 4 hours, and then when he's done with that, he goes over and he, say for example, seeds that area, or maybe lays some landscaping and irrigation pipe down in that area. How do I handle that person? And this can be a tricky question because there's 2 different answers, and it depends on, you know, kind of the difference between the rates and what's going to be administratively more feasible for you. So if you have an employee that's doing more than one classification, particularly in a given day, the first thing that you can do is you can simply default and pay them the higher rate. And so depending on what the rates are on this category and what you're paying that person to physically be on your job site, it may not matter. And you may say, you know what, both of these rates are lower than 20 bucks an hour and I'm paying them 20, so I'll just call him a loader operator all day long because it doesn't matter, right? Because whatever he's doing is lower than what I'm paying him. However, if you're not paying him higher and you are paying them, you want to pay them exactly what it is that they're doing, then you have to literally track what they're doing and the time that they're doing it per day. And this can get tricky simply because you have to actually eyeball them every minute of every day. You know, how long were you on the loader? When did you get off? You know, why did you get off? You know, did you get back on the loader after that, or did you go somewhere else? So is that all continuous time? How do I cover break time? And then how do I prove it 3 days later, right? So our experience is that if you try and track it one by one, there is always the possibility that even if you think, hey, he did the loader for 1 hour and he was a laborer for 7, it's always possible that your employee will tell the Department of Labor, oh no, it was more like 4 and 4. Or actually, I think it was more like 6 hours that I was the high price thing and only 2 hours that I was doing the lower price classification. And that can be very hard to prove because there's generally not going to be, you know, extensive contemporaneous documentation of what they were doing. So it is a possibility. And again, there are states and counties where the rates are so different that it makes sense to do it. But for you, depending on how much you're paying your employees, if administratively it doesn't make sense because you're paying them more, then I would not advise the second option. I would advise the first option, which is to classify them as the higher price category and kind of roll with that. So here is a different type of wage termination. This is also from North Carolina from January of this year, but this is for highway. And the reason I mention this here is because now when we look at power equipment operators, we don't have 6 categories. We've got 20 plus. And so again, depending on the type of work that you're doing, it's very important to know exactly what that employee is doing. And even within these categories, you have to look back at the back of the wage termination to try and figure out, you know, what category do they necessarily fit into. So for example, if you look about halfway down through power equipment operators, you see that there's a loader, but there's 2 different rates for loader. And they're not drastically different, but they are different. And so even the size of your loader, whether it's a 2 cubic yard bucket or a greater than 2 cubic yard bucket, the size of your loader can make a difference in what people get paid. So it's important to know not just what they're doing, but also, you know, the size. And I've seen ones that are also based on horsepower rather than bucket size, but, you know, what specific type of equipment was my person actually on? Okay. Certified payrolls we've already talked about, so this is just kind of review and wrap up. These go to the government every week, 7 calendar days after the regular payment date of the payroll week that's covered. So again, if the payroll date ends on the 7th, your workers get paid on the 14th, and that certified payroll is due to us on the 21st. Okay. Subcontractors at every tier need to comply, and both the contracting officer and the Department of Labor have the right to enforce compliance and look at those certified payrolls. We are sending them hand over fist to the Department of Labor. They ask for a lot of them every week, and again, we've been working very closely with them to make sure that they have them and that we kind of stay off their radar or on their radar in a good way, which is that we have contractors and subcontractors that are in compliance with these laws, which is, you know, something that cannot necessarily be said for all the workers that are working at these particular facilities. Penalties for non-compliance, we've already talked about back pay a good bit. Audits is not necessarily a penalty, but it kind of is because it certainly is disruptive to your work. The U.S. government can withhold money from the prime contractor, so you can certainly expect that the prime contractor would withhold money from subs and further on down the line. I mentioned with QASA, there's also a liquidated damages clause that can add up. For the prime contractor, you can get poor performance evaluations. And then if, again, you are willful or a repeat offender, you could even be suspended and debarred. And that's just not for primes. That can happen to a subcontractor. In fact, it frequently does happen to lower tier subcontractors because they tend to be less serious and sophisticated about how much government work they want to do forever and ever. So when they have big problems, sometimes they don't put up much of a fight and they just get suspended. So a summary of our pitfalls: we talked about making sure you've got the right wage determination, highway, heavy, building, make sure it's the proper one for the type of work that you're doing. Make sure that you picked out the proper job classification. Make sure that you have properly paid time over 40 for overtime. Make sure that you've broken out that cash and fringe, 2 different line items. If there's a wage termination that says you have to pay somebody $15 an hour in cash and $1 an hour in fringe, don't just write down that you paid them $20. I've seen cases where the Department of Labor will come back and say that was very nice of you to pay them $20, but there's no record that you've paid them $1 an hour in fringe. So we're going to give a back pay order of $1 an hour for all the fringe that you didn't pay them. When it's clear what their intent was to pay more than the total combined, and that's nice and it's friendly, but from a paperwork and a Department of Labor enforcement point of view, they will not be terribly sympathetic. Okay. Other pitfalls, and this is particularly for subcontractors: do not approve your lower tiers invoices until they've turned in their certified payrolls. Again, can't emphasize this enough, particularly if you have subs that are coming and going. If you've got subs that aren't working out and then they leave, if you pay them their final invoice before you've got their final certified payroll approved, you will never get their final certified payroll. And that will unfortunately revisit itself with regards to your invoicing on a go-forward basis. So make sure that you have certified payrolls from everybody underneath you. And again, this ties into the importance of why it's important to know who's underneath you. You can't just subcontract out your work and say, well, you know, I know it's getting done. You know, I'm not really clear who's doing it. I gave a subcontract to ABC Corporation, but I don't know if they brought in other contractors or not. It is imperative that you know, because if you don't know, then you don't know if those other subcontractors have turned in certified payroll, and ultimately that could have an impact on your invoicing. All right, other pitfalls: we talked about misclassification of employees. The last bullet point there is just looking for differentials, but I don't think there are any on the North Carolina wage terminations. If you're listening to this webinar in the future and you've got a different geography, again, look at your wage termination cover to cover, because sometimes they do have different differentials: night shifts, hazardous pay, locality differentials, a variety of different little uplifts. Again, it really just all depends on the geography of where you're working. So internet resources, you'll see these on the slides when we send them out. The Department of Labor website is obviously kind of the #1 place to get all of your forms. I won't go through the review questions for purposes of the webinar. That's more of a kind of in-person activity. But what I will do is we'll get to our who to talk to people, and I will leave it on that slide in a moment, and then we'll go through some of the questions in our remaining time. So the last substantive bullet point here is the SF 1413. I referred to it earlier. This is the form that you fill out that identifies who those lower tier subcontractors are. And as you see here, this is kind of what the form looks like. Most of you will have received this already, should be turning it back in. It's very, very important to us that you not just turn this in once when you start your job. If you change subcontractors, this form should come in revised. Okay, if ABC Corp leaves the job and you hire LMNOP, I want a new SF 1413 dictating who that is. If you're aware, or when you become aware, because you should be aware, that LMNOP has hired XYZ as their subcontractor, then this form should come in stating who their subcontractors are. Okay, and as you see here, you'll see not just our sub, but your sub, and then whoever these second tier subcontractors are, as you see at the bottom. It's very, very important that we keep constant track of who's on the site. As some of you may know, this also ties into issues with badging. I think it's going to continue to be an issue, but the accountability and transparency of who is working on the site, what they're doing, and where they are is important from a compliance perspective, a security perspective, and also from a safety perspective. So there's going to be continued emphasis on identifying who you are bringing onto the base in terms of your overall supply chain. Next slide here has a handful of internet sites. I'll let you look at those on your own time. And then I'll leave this slide up while I go through a few questions in our remaining time, but this would be a list of people that you can call or talk to with your questions as they present themselves. Okay, so as I look through a couple of the questions, can I get a copy of these slides? Yes, of course, we'll send these out to a variety of people. For the deduction portion, somebody has asked, we usually do not work on one project per week. So should I break down any type of child support and insurance and put it on the form also? This one is probably kind of a specific question that I would ask one of your people, but in general terms, yes, you want to show those deductions. But if they've worked kind of half of their time on a DBA project and half their time, say, on a commercial project, so you're not really reporting all their wages, you know, we want to make sure that the tax part of it is not over recorded. So, you know, for example, if you only report 20 hours because that's all the DBA work they did for the week, you won't record their entire tax deduction for the week. You would only record that portion of it which is related to those 20 hours. In terms of garnishments, I don't think it would be harmful to include the entire amount of the garnishment. And I certainly, actually, I think that would be preferable rather than trying to prorate it or something like that. We have another question here that says, if the apprentice wage is over the minimum wage, do we even need to mention it? I think the answer there is probably not. I mean, if you have an apprentice and they're certified and you have the DOL paperwork that speaks to that, you can check that box. But if you want to keep it simple and the apprentice rate is $13 and you're paying somebody $22 anyway, then no, there's no harm in not checking that and move it over. Next question says here, if we have an employee on a week-to-week basis, but they quit and they come off of the certified payroll, do we need to be notified? And I think the answer to that is no. Again, it's helpful to us if we receive a payroll every week, even if you aren't doing any work. But once we receive that payroll, we will assume that, you know, if John was on last week's payroll, but he's not on this week's payroll, that either he took the week off or he went and found other employment. That really is not important. So we're not tracking employees to that level of detail. We are tracking companies to make sure that we have a payroll for every week. But once we see a name that appears, we're not going to track that individual to the end of the job. We do realize that there are a lot of employee turnover in this industry, and I think that would probably be a bridge too far to try and track every individual person to that level. Couple of questions here deal with the same topic. If I have a project manager that works a few hours on site, does he need to be on the certified payroll? And do I need to put my salaried quality control personnel on my certified payroll? And the answer to both of those questions would be no. From my perspective, you know, without, this is of course a general answer to what may be a specific question, but from my perspective, those are not laborers and mechanics. The first one is obviously a project manager. He would be exempt under the EAP exemption, assuming that he manages the project, has the ability to hire and fire people, is supervising the work of 2 or more people. Same thing for your QC representative. That's a salaried position. It's not a labor or mechanic. It's not a craft or a trade. So those people would not be on your certified payroll. Couple of last questions here. In the case where a category is not clearly identified in the wage determination and it would be difficult to fit the discipline, what are the options? Specifically, let's talk about an abatement contractor where there's not an abatement contractor category in the wage determination. So that's a good example of where we would probably want to have that discussion one-on-one, fact-specific with the subcontractor to say, okay, what is this employee doing? Is there any category here that fits? Can he be shoehorned into another category? Or is this genuinely a case where we need to contact the government and talk to them about starting that conformance process? And I don't want to take up everybody's time with that. But you know, if you've got something that's that specific that you can't fit them into a category, this is certainly where we would look at it. Next question, do I need to split pay per the form on the wage determination sheet, for example, $13 an hour with fringe of 32, or can I just write that the employee is making $14 an hour? I would advise to do the former, because as I mentioned in my example, I have literally seen where the Department of Labor has come in and said you didn't break out the fringe, therefore I will assume you didn't pay it. Yes, I see that you quote unquote overpaid on the wages, but since there's no record of fringe, we're going to give a back pay order. 100% I've seen that happen on Service Contract Act jobs. I haven't seen it happen on a Davis-Bacon Act job, but when the solution is simply to have 2 lines on your payroll form rather than 1, I would do that and eliminate any possibility of confusion or risk. Okay? So I think that's about it. There's a few more questions, but I'm a little bit over time. Please, I will leave this open. You can continue to submit your questions. You can also submit them to your contract administrator, and we will do our best to get all of those questions answered either globally to the group or on a one-by-one basis if they're kind of very fact specific. Again, thank you all for your time. The goal here of everyone is high side compliance, to not have Davis-Bacon Act violation findings, and for us not to have withholding, and subcontractors not to have withholding, and for the Department of Labor to find something else fun to do with their time that doesn't involve looking at our projects. And the way that we get there is, again, by being very proactive in our training and our compliance, and making sure that this training gets flowed down to subcontractors at every tier. So with that, I will sign off. Thank you again, everyone, for your time. Please continue to submit your questions, and we will follow up with the materials and answer those questions in the next few days. Thank you again, and I appreciate everyone's cooperation and compliance on these projects.